So without further ado, let's talk about our experts. Who would like to go first and give a little background as to who you are, what you do, and what we're going to be talking about today?
I can go first. So good afternoon, and thank you for having me. I'm happy to be here, a part of this panel. I'm the Miami-Dade Vice President for Castle Group. For those who are not familiar with Castle Group, we are a privately owned property management firm, proudly managing associations all across the Sunshine State from the Keys to Jacksonville.
Jonathan, go ahead. Good afternoon, everyone. I'm Jonathan Goldstein from Haber Law, PA. I'm board certified in condominium and plan development law and the chair of our firm's community association practice. I want to thank Audrey, Jessica, and Castle Group for inviting us to participate in this webinar. Thank you so much. Thank you all attendees for being here as well.
My name is David Podine. I'm a partner here at Haber Law. In addition to focusing on community association law, I also focus on construction projects and real estate law as well. I like to say we can help you with everything from the dog violation letter up to the multi-million-dollar special assessment loan and construction repair project. So thank you very much to Castle Group for having us today.
Great. And I'm Jessica Raffo, Assistant Business Development Manager, and David will actually be moderating and I'll be co-moderating for today. We normally don't do this, but we thought it was really exciting to maybe have an attorney with all their background and expertise moderating this webinar. So these are some of the topics that we will be discussing today. Mainly, we've been surveying a lot of our attendees, and this seems to be what they're really interested in, right? Collections and assessments, given our current reality with COVID-19 and the unstable economy. We're going to have a mid-year review and some best practices around committee and emotional support animals, all the good stuff. So without further ado, let's go ahead and begin. I'm going to pass it on to you, David.
Great, thank you very much. So our first topic is going to cover collection and assessments, and then related to that, we'll get into budget and lending. Then we'll go over mid-year legal review in terms of new Florida statutes, as well as some important case law that has come out. And from that, I want to kick it off with collection of assessments. And on that topic, I think it's important to point out, where we are sort of locally, at least in South Florida. Recording this on August 4th. We just had on the end of July or August 1st, Governor DeSantis extended the moratorium on foreclosures and evictions. Unfortunately, we have very difficult economic conditions out there. It's not necessarily broad-based on all industries, but particularly here in South Florida with our heavy focus on tourism, hospitality, and other related industries are particularly hard hit from the economic impacts of COVID, which then ties into, many of those residents and owners all live in community associations. And so with that said, we also have a number of emergency orders and restrictions that are still in place, whether in Miami-Dade County, Broward County, Palm Beach County, and then sometimes even different within the municipalities within those counties. So sort of with that backdrop, I'd first like to ask Audrey, what is she seeing and hearing from her team, from the communities that she works with respect to where they're at with amenity and common area closures, and then are they starting to get questions about assessments and potentially discounts? And then I'm going to ask Jonathan to speak to the legality or the legal options available to associations on that issue.
So thank you, Dave. Yes, for sure. Most of our associations have their amenities open with restrictions. Obviously, they are limiting the head count of those who could be in any amenity at any given time to make sure that we can practice social distancing. Additionally, they reduced hours to the amenities that they're open to make sure that we can properly and adequately sanitize between the use. Owners have presented the inquiry of reducing fees as a result of amenity closures. And, as you may probably agree with me, assessments also referred to as maintenance fees, right? So, and the purpose of the fees is exactly for that. It's to maintain these amenities, right? Whether it's, servicing the equipment, cleaning it. A great example of that is the pool, right? The pool still needs to be maintained to meet the Department of Health permit requirements. The gym equipment still needs to, be serviced and inspected. So in some cases, amenities maintenance is a small portion of the overall budget. So, obviously our recommendation is we're not reducing the fees as a result of, you having limited accessibility to the amenities or because they're closed. Your thoughts?
So Jonathan, with that backdrop of kind of hearing what's happening on the ground at properties, legally what tools are available in terms of discounts or not, or enforcing the budget and collections?
Well, first of all, we totally agree with Audrey. The association's assessments are based upon a budget that's adopted by the board of directors. It encompasses all kinds of maintenance and servicing and obligations and insurance. So it's not necessarily it's not going to be affected. And if it's affected, the association board can amend the budget. But the assessments are based upon the budget, not the level of amenities that are opened or closed at a given time. And there's actually a line of case law over the years that talks about how owners can't be excused from assessments just because a maintenance or service isn't being provided as anticipated. That the obligation to pay assessments is unconditional as long as the assessments are adopted correctly. So going further from that, but just one last point. I think ironically, the changes with COVID are going to increase the budgets because it's so demanding on the requirements for sanitation and enforcement relating to the various conditions.
Additional staffing.
To open amenities. But so in terms of enforcement, the association has several remedies at its disposal. The traditional remedies first, the association always has the right to collect assessments through a lien on the property. Now, whether it's an HOA or a condominium, lien has a process that takes time. It requires plenty of advance notice. There's a 30-day notice for condominiums, 45 days for HOAs of an intent to record the lien. Then you record the lien. Then there's another notice contemplated by the statute of an intent to file a foreclosure action. The foreclosure action would then have to be filed to foreclose the lien. So it's a long process. And so while on the one hand, associations may want to give some sort of brief forbearance, and that can be discussed in a given instance and how to do that correctly, taking too long in that process and giving too much time can really set an association back on collections because of how much time it takes to enforce the association's remedies. Additionally, it shouldn't be overlooked that associations can collect to get a money judgment against the actual owner. Like, for example, if the property is foreclosed by a lender, the lien is against the property, the unit. So like if a lender, first mortgagee, forecloses and takes title to the property and the association has no recourse through the unit, it can go after the former owner. And in some associations, that's a viable thing to do. And so it shouldn't be overlooked. And then finally, you can collect rent from tenants when units are in collections, depending on the age of the association, its governing documents, et cetera. There are statutes now that allow you to collect rent.
So I have
also declaration provisions. Sorry.
Jonathan, no, that was great. And David, if I may, I actually have a question that came in, and it has everything to do with what you're talking about. Now, this is interesting because I almost feel like there's a bit of a moral issue here as well. So someone, typed in that they have a resident who entered into a care facility, and the children are trying to sell a co-op in New York to help pay for the assessments and special assessment fees due to the condo. Now they are about $3,000 in the arrears, and they want an extension or some sort of forbearance to give them some time to sell this co-op over in New York City. So it seems like they're trying to do the right thing, but obviously, the woman is in a care facility and things like that. So they're a little concerned as to what they should or shouldn't do. Like what would you say to someone like that who's in that situation?
Okay. really important question and understandable. And, I'm not here to be the person who says, because of economic factors, you cannot ever, try to forbear or do a payment plan. You have to collect immediately. No, I don't think, of course we have to be sympathetic. We're all human beings. So if a board of directors says in our business judgment, we want to have some flexibility, we understand that. We all understand and sympathize. There's some legal ways to deal with this. So first of all, the principal thing is you can't waive assessments. Okay, if you waive assessments, you waive it for everyone. Okay, you can't just forgive assessments. But if you delay the obligation to pay, okay, that conceivably could be okay in terms of saying, well, we're gonna allow late payment for the first installment, for example, but you have to do it really uniformly. You don't want to be picking and choosing, especially as it relates to charging interest. Okay. Because you have an obligation to charge interest, it's in the statute, it's in the declaration. But associations can say, well, because of hardship and COVID, under certain circumstances or universally, we're going to allow a certain delay, and we're going to say the payment will accrue a little late, and we'll defer interest until that point in time. In a given case, associations can enter into payment plans with owners. Okay, to work out some sort of repayment of the entire amount, but that doesn't have to be immediate. Okay, and so that repayment plan could avoid the accrual of legal fees, of having to send that to legal counsel. You can talk about maybe, a policy that's across the board in the association to forgive late fees. But again, I strongly encourage uniformity in how that's applied. And so if you're going to have certain criteria for that, you discuss what it is and apply it uniformly through a uniform, say, COVID collection policy. Same with interest. But again, you can do payment plans. There's flexibility for that. There may be flexibility in terms of delaying accrual in terms of the interest obligation, what's considered delinquent. There's no forgiveness of assessments. And at some point, there's a tension between having payment plans and wanting to be paid and allowing people these kinds of deferrals versus the tension of having to proceed with your collections because of the risk of losing remedies and the ability to collect. And what I'm referring to is eventually down the road, there's a first mortgage. And if the first mortgage forecloses first, it could significantly prevent the association from collecting that balance. And so if this extends over a long period of time and the first mortgagee takes too long to foreclose, the association hasn't acquired the unit and rented it out, the association could be left with an uncollectible bad debt, something it'll have to consider right now in terms of budgeting, et cetera, that we can talk about separately. So there is a tension between this desire to be sympathetic and have reasonable, good faith plans to mitigate people suffering and help people out versus the obligation to proceed with collections diligently to minimize bad debt in the long run.
Now, John, question. I think we all know that COVID-19 has presented some unique challenges, right? In the real estate market and, the sale and leasing of units. And, there's an order right now that evictions are currently suspended, right? So how are we managing that, or how is that playing into the equation when we're selling units and they have a current tenant, right? They're in the middle of a lease.
That's a great point. That's an issue. In the short term, while the eviction moratoriums are in place, if an association is close to taking title potentially, et cetera, the association has to factor, well, if we take title, are we going to have a non-paying tenant in the unit that we can't evict, right? Maybe you can work something out with the tenant to mitigate, get paid something over some period of time. There's certain protections for tenants. Protecting Tenants in Foreclosure Act requires a certain notice. Anyway, 90-day notice if there's a bona fide lease. The governor has issued a moratorium, as we know. So absolutely, that's one of the factors an association should take into consideration. But in the long term, like 6 to 12 months, the eviction moratorium isn't going to last forever. And we're kind of talking like in the 6 month to 1 year horizon, is the association going to be ready to foreclose if necessary. There probably won't be, maybe there won't be an eviction moratorium in place then, and has the association positioned itself to act to, recover rent from the unit to mitigate its losses, and bad debt? Because when a mortgagee forecloses on a unit, they are entitled to a safe harbor statutorily, 12 months or 1% of the mortgage. And so if a first mortgage forecloses on the unit and takes title, the association gets none of the past due assessments from the prior owner except the safe harbor, creating bad debt. So one way associations can mitigate that loss is by acquiring the unit in foreclosure and renting it out. But of course, while there's a moratorium on evictions, if you have a non-paying tenant in the unit, what are you going to do to get the rent? You're not really going, you're going to be a little powerless in terms of renting the unit during that period. So that's definitely a big factor.
So I actually have some questions that are dealing with foreclosure here that are coming in. I have a couple, maybe three. So one of them is, can the association foreclose in a property that has been past due several months prior to the pandemic? So if they were already late, can they take any action, or it doesn't matter because there's a pandemic?
Yes, the association can foreclose. We have units that are in foreclosure. The issue is the foreclosure moratorium by the governor. It's like the eviction moratorium. For the short term, the judges are not going to allow the sale, while there's a foreclosure moratorium in effect. And there may be some issues, in terms of, well, does it apply to condominium association liens, et cetera? But what we're finding is it's being applied broadly.
So,
David, you want to add anything on that?
to clarify, so I understand not moving forward with the foreclosure, but would it be the recommendation to still secure your interest by filing the lien, or is there a moratorium on the liens as well?
Not at all. You would want to protect your interest. I will say that there's a 1-year deadline to file a foreclosure when you record a lien. So once you record the lien, you're going to have to file a foreclosure within the 1 year to be able to foreclose. But it's something that you do want to protect your interest now. You want to position yourself. The association wants to position itself to avail itself of its remedies when the time comes. Because again, there's the pressure of the potential first mortgage foreclosures. David, you want to add anything on this?
Just that I think it ties directly into our next subject, which is budgets and lending, which I think on a couple of points that I heard, it's important to keep in mind the macro perspective and the micro perspective, because obviously we need to keep in the micro perspective of the human effect of what's going on and the position that certain people are going to be in because of COVID-related problems, but also the macro concern is the association only has one pot of honey, and that's collecting the assessments from the owners and spending funds pursuant to the budget. And most budgets have a certain amount of bad debt or a collection contingency built in, but no one certainly foresaw that we would be having the types of unemployment numbers and economic distress this year, probably when they pass their budgets. So related to that issue, I'd ask Audrey, are you already seeing from the properties that your teammates work with, are they already starting to look at how's it going with their budgets? Where are they in terms of the amount of bad debt, or trying to project out, hey, we had budgeted this much, but costs have gone up by X, collections have gone down by Z. Are you already starting to hear those conversations?
Yeah, we actively we're anticipating that, right? Just by nature of the fact that, all of a sudden we had to engage these commercial companies to do the sanitizing, and then there was legal costs that kind of went up with implementing new rules, getting legal opinions on rule enforcement. So Castle kind of started a couple months back tracking the expenses, the COVID expenses, and breaking out a line item for that. So really provide a good visual for our boards as we're in budget season now. We're already have issued our first draft. And so yeah, we are definitely taking that into consideration and seeing where we need to offset in future forecasting of, do we want, in some associations, we've amped up the personnel, right, to continue to proactively, disinfect and maintain the community. So without question, we're looking at that and figuring out, should we look into doing a line of credit? What was very interesting is I think we've always talked about keeping 2 to 3 months of operating expenses in your account. And I will tell you, for the associations that took heed to that recommendation, they're thankful right now, right? And those who haven't have learned a lesson and are looking forward at how they're going to start building up that operating surplus, because even now there could be challenges in getting access to capital through lines of credit, right? So
Right.
we're considering all of those as we're reviewing our budget.
So exactly on that point, so if there's associations that are facing a potential shortfall or an actual shortfall, Jonathan, what are some of the legal tools available for associations that might already see that they have a problem with their budget or planned expenses and need to plug that gap?
Well, first option, as I alluded to before, is amending the budget. That's one thing, but that's diffuse. It takes more time to collect that. So associations are going to want to look at more immediate remedies, right? So there's a bunch of tools at the association's disposal. First, the association could look at a line of credit or a loan, right? So generally, the association can borrow money regardless of what the documents say. The documents don't have to provide the power to borrow money. Borrowing money is an inherent power of an association. But the documents will provide certain approval requirements. And if they do, the approval requirements generally have to be followed. Now, because of COVID-19, there's a debate, there's an ambiguity about whether the emergency powers can be used so that you need no membership approval, just a board approval to borrow money, regardless of what the governing documents say. Attorneys who are willing to opine that the emergency powers apply in this particular condominium association or HOA, and so you have the right to borrow money without a member approval. They can arguably circumvent member approval requirements in the documents because of the emergency power statute, but a lender has to be willing to underwrite that, and many lenders will say, nope, we don't believe the emergency powers are intended to apply this way. We're not going to accept that legal opinion and loan the money. Some lenders will, some lenders won't. So that's an important consideration. There is a debate.
And I want to jump in right there. As someone who's represented associations in loan transactions as well as lenders in condominium lending, I don't think you're going to see lenders be too excited to even rely on that, because they're going to take it a step further and say, you need to demonstrate to me, association, the borrower, how you're planning on repaying this loan, this line of credit, by either A, passing a special assessment and showing me you've passed a special assessment, or B, showing me you've passed an amended budget that includes paying the debt of this new loan or line of credit. And so it sounds obvious if you operate in this world a lot, but many times people think, okay, we'll get a loan, but the banks are going to require, the lender's going to require, how are you repaying that loan? I want to see the amended budget now or the past special assessment now.
Right.
Are you already starting to see properties that you and your team work with? Are they looking into getting loans or lines of credit or other financial tools?
Well, by way of sheer best practice for Castle, we do highly recommend, even before COVID happened, that they kind of set themselves up financially to have a line of credit, right? And whether it's an emergency line of credit or if it's associated with construction projects. What's interesting, I wanted to mention to Jonathan, because we're not really faced too often with amending our approved operating budget. Typically, we would default to just doing a special assessment. But so for some clients who are not familiar, it's not too complicated of a process. You really follow the same process you did in adopting your original budget, which is you amend your budget, the board approves it, sends it out with their 14-day notice, call a duly called meeting, unapprove the budget to adopt it, right? Correct, Jonathan?
Yeah, it's really a board vote. And certain considerations apply, like if the budget exceeds 115% of last year's budget, members can petition. It's like a complicated process that I've never seen successfully implemented. So yes, boards can adopt an amended budget, and it's very easy to do it, actually.
Yeah.
There's other things that relate to an amended budget, including reserves, right? I think when you talk about the budget, using funds and amending the budget, you got to think about reserves. Reserves are a first place to look here under these circumstances for additional funding. The vote to use reserves, first of all, reserves can only be used for the purposes they are earmarked for. So there's two types of reserves: pooled reserves and straight line reserves. So a straight line reserve is in a mandatory account that is for an item exceeding $10,000 in replacement costs or certain statutorily defined reserves that are mandated, like painting, etc., roof, and there's others, paving. So those reserves are fixed in an account. And if it's a straight line account, the roof reserve can only be used for the roof. The paving can only be used for whatever. But in a pooled reserve account, you have a pool. You define the parameters of the pool. The pool should be defined and limited to real reserve items, capital improvements and replacements, not like an operating contingency fund. The pool then can be used for any purpose the pool is designated for, which gives you flexibility to use it within the pool. But you still cannot use the pooled reserves or the straight line reserves for an alternative purpose they are not earmarked for without a member vote. But the member vote is relatively easy to obtain. As long as you get a quorum of the members at a member meeting, a majority of the members present can vote to use reserves for an alternative purpose. So this is like one of the low-hanging fruit areas to get more funds, because you might have a replacement cost item, an item with a remaining useful life, 20 years, 30 years that you're already reserving for and have a large reserve fund for. Okay, well, you can now use that for an alternative purpose right now when you have a crushing operating shortfall through a relatively easy vote of the membership. But again, you'd have to do the member vote correctly. Majority of the members present at a meeting with a quorum. Alternatively, you could do a special assessment. A special assessment is going to have approval requirements set forth in the governing documents. The board sometimes can approve a special assessment. Sometimes the membership has to approve it. Sometimes it depends on like a monetary threshold or percentage of the annual budget that's stated in the governing documents. And the thing with special assessments they're like a reserve once they're assessed, because they can only be used for the purpose of the special assessment. They can't be used for anything else until that purpose is completed. But if you get a special assessment for particular things to cover the operating shortfall, then you can use the money for that purpose, and it's another good way to potentially fund that operating issue.
Got it. So, we heard about special assessment or amending the budget, and or looking into loans. Audrey, are there other sort of financial or management tools available to associations in terms of just revisiting existing items, whether it's through cost cutting or vendor contracts or things like that you can speak to?
Yeah, I think it's a natural process of we may be in a position where we need to really kind of analyze.
Tighten the belt.
I'm sorry?
No, to really tighten the belt of the association.
Right. Whether it's kind of rebidding all our services, talking with your existing vendor partners and saying, hey, we're all kind of impacted here. We have a great relationship, but this is where we need to be at this line item to kind of get us through these circumstances. Again, reviewing your interest rates. What are you earning on your current investment? Your funds that are sitting in your interest-bearing accounts. So there's definitely lots of opportunities to kind of skin the cat here and cut costs, and just really it's a combination of all these tools to get us in a good place and overcome this.
Great. And Jessica, I know we're getting a bunch of questions. Some were submitted in advance, and I see it seems like some people are also submitting questions now. Do you want to take a chance if we can go over a couple of the questions that are sort of on the financial aspects, if we've received some more?
Yeah, absolutely. We have a few that have come in live. So one of them is actually going back to the foreclosure discussion. So what happens if the unit if the unit is under contract to be sold, but due to the COVID-19 situation, the closing has been delayed and the unit is in arrears? Should we proceed with the foreclosure action after the moratorium is lifted, even though it is under contract?
Well, typically, when a unit is delinquent, the new owner is going to be jointly and severally liable and will request an estoppel to pay off the debt of the prior owner. So if you're in a situation where a unit's under contract and there's a potential closing, there's going to be an estoppel request. The estoppel request will state the payoff amount for the prior owner's debt. So on the one hand, that's a situation where the association has good prospects, if the transaction goes through, of getting paid in full. That would include any legal fees, costs, interest, late fees incurred in the collection process. And so that said, you'd have to look at the dynamics of a particular situation to know how that affects your collection process. So for example, you have a foreclosure moratorium right now. So right now, that's a situation where you're going to hope that the closing happens to get paid off in full through the transaction. You're not going to foreclose anyway while the moratorium's in effect. But if you're sitting saying, should we record a claim of lien? That depends on the timing, the nature of the transaction. Yes, you'd want to record the claim of lien, perfect your interest. You'd want to be continuing with your collections process, but then you may halt it a little bit to mitigate the fees on the estoppel. There's different considerations in the particular instances.
Great. And this one relates to, our conversation regarding budgets and lending and what does require a member vote and what doesn't, seeing as we are, in the midst of COVID. How do you get a member vote in a Zoom meeting?
That's a real issue. There's different things you can do. And I say it's a real issue because and I speak with other condo attorneys, obviously, in the industry, and we, it's like you hear horror stories about meetings, and I mean this. You hear literal horror stories about people having to go physically to member meetings that are out of control, right? Where, okay, there'll be social distancing. Okay, we'll do it the right way. But really then, too many people show up at the member meeting in person. Some don't wear masks, and people are literally fearful for their health and safety. So this is one of those issues where you can't think about it in the abstract.
Jonathan, really I'm gonna give you a hard time and play devil's advocate. What's the difference? Zoom meeting, not Zoom meeting, COVID, no COVID, unit owner vote, proxy goes out, people have a chance to vote on it, mail it in, and socially distanced ballot box is placed somewhere in the property where people can drop things off. And why is it any harder? And I'm not even talking about e-voting yet.
First of all, e-voting is a great solution. The question really goes to this technical question of, do you really need to have a physical footprint meeting to have a member meeting? Is there some sort of obligation to do that? There are arguments that you do not. And in fact, the necessity and safety point I was making before is the best one, that it would almost be irresponsible in some cases to have a member meeting in person, because you couldn't assure compliance with social distancing requirements, et cetera. So I think that there is a good faith argument that you can have a member meeting by Zoom and treat it like a physical meeting. There's Not-for-Profit Act, provisions that you might be able to default to that govern like digital meetings, and you could potentially point to that. I'll say this, there's been a lot of discussion in the legal community for community associations about this very issue, because there's questions like the emergency powers didn't think of this, right? Like the emergency power statute doesn't have a provision that says unit owner meetings can be conducted by Zoom exclusively without any physical. So while it's an ambiguity legally, from a practical and realistic standpoint, it's not that ambiguous, I think. You can have member meetings by Zoom. You should. You can maybe have a physical footprint where somebody's in a room and you tell everyone you can't come because of CDC obligations and guidelines, and governmental obligations to maintain social distancing. So we're having a physical meeting, but you're going to attend remotely, and people can be there by Zoom, so to speak.
Right.
I'll tell you one other thing. There's an alternative to meetings altogether. It's called an action by written consent. Many documents and the statutes allow this, which is if you can get enough votes by signature on a page, you can do the action without any meeting whatsoever, Zoom or otherwise, through a written consent. And then the board can just meet, to do whatever the board has to do. But a member meeting can be done on paper only through written consent under many circumstances. So that's just another food for thought.
So Jonathan, so that's interesting. So a couple of things that have come up. So I've had a couple of questions now, which I think you responded to, right? Some people are saying, well, can we host this physical meeting with a 10-person limit and then include Zoom? That way it's open to the membership. So when I think practically you're in Zoom, and I guess do people vote on this via chat and then someone will just have to write it down? Because how do you count those votes? And then when you're talking about this this ability to sign it on paper, I mean, what would be your recommendation? You just send it from unit to unit or to resident, or can we involve DocuSign or like any technologies like that where they can sign electronically? I mean, is that still valid?
Yeah. So if you're doing the written consent approach, yeah, you could do DocuSign, you could circulate it through email and have people print it and sign it and send it back. There's many ways to do that. Again, in any case, the association talks with legal counsel, they come up with a way. But written consents are a way in many cases. So it's like something that can be overlooked, but it's like one step easier in terms of, instead of navigating the complexities of, we need to meet in person and have 10 people there, and then you have Zoom to supplement. But let's assume you have to do that. You have to do the physical meeting, right? Or the meeting remotely by Zoom. Again, the election is really where it becomes complicated, right? Because you have the independent committee that has to look at the outer envelopes and the emergency powers let you postpone elections to some degree, obviously. But then you may have an issue. Maybe you have a process where there's a committee of a couple of people socially distancing in a room, but then everybody else is on Zoom. There's many different ways to deal with that. Every association will come up with a strategy for that. I'll say that remote meetings can have polling options, right? So you could set it up like a seminar. And so you have certain people, the presenters control the meeting. No one can participate without holding their hand and being called on, so to speak. Then they can speak their piece. When you have a vote, you would have a means of having every person present vote through the survey, and that would be limited through whatever technical means you use to like make sure that people only vote once, through their ID for the meeting. Again, these are just potential solutions to this quandary. And yes, people could vote, but in most cases, as a practical matter, people will vote by limited proxies at member meetings.
Or even, I just did when we had an annual meeting in election, and it was via Zoom. They had the manager, the association counsel, the election monitor, and then the e-voting vendor, all 6 feet apart, gloves, masks. And then they had the Zoom going with multiple video points showing the table, and then 2 volunteer counters, so showing the counters, showing the e-voting person, showing the manager, and it worked. It was a little complicated, but it worked. And they even had to count physical votes that people mailed in with secret ballots, compare against the roster, see who was signed up for e-voting, make sure there's no double voting, then go through the e-votes. But it worked, and you could see what was going on.
Excellent. And I know Castle has cataloged different platforms of technologies that our associations have been using. So if you're interested in that document, you can just email info@castlegroup.com. And we have a lot of resources regarding the creative ways that our associations are, coming up with these difficult solutions, right? We just have to think outside of the box and adjust. So that's excellent. So we only have 20 minutes left. I'm sorry, Audrey, did you want to chime in?
No, I mean, David hit on it. Just, now is the time to start thinking about that and making sure that whatever strategy you implement for your site for these annual and budget meetings, that, it's the right fit for your community.
Yeah, and I would just throw into one more thing. The declaration is an important tool. that can limit or empower associations. And now is a good time to revisit the declaration and what it says, because in 6 months, if financial situations get worse and there's a domino effect, you're going to want good provisions for this scenario. So like, for example, some old declarations limit the liability of third-party buyers at foreclosure sales. Well, that hurts associations big time and could possibly be amended right now. And that could be, you know, a solution. You could amend the bylaws to make it easier to do these types of meetings. You could do different things in the governing document, make it easier to borrow. So there's a lot of different things you could do in the declaration that it's good to look at and get ahead of.
Excellent. So this is great. I mean, we should just do a webinar just based on collections and finances, but this is a financial and legal brief. So let's go ahead and move on and spend the next 20 or so minutes discussing the mid-year review and some of the legalities that we're seeing in the space today. So Jonathan, you'll take it from here.
Sure. David, did you want to go through any of these things, you know, a list for the mid-year review, or do you want me to just get started on?
Yeah, just in terms of, you know, on July 1st, we had the governor sign a number of bills into law that Jonathan's going to touch on with respect to emotional support animals, committees, some new minor changes on 55 and older communities. And I think it'd be helpful to then hear from Audrey in terms of, you know, what kind of issues that she and her team have faced on those topics. So Jonathan, can you give us some details on what exactly are the new laws?
Yeah, sure. So, sorry, excuse me. First of all,
you sound like Darth Vader, Jonathan.
Yeah, I know. For some reason, all of a sudden, I'm getting like some sort of feedback. Apologize. So first of all, the big change, I think, bigger than all the others by far, is the changes regarding emotional support animals. Senate Bill 1084. Provide a quick overview. House Bill 255 deals with the Florida Commission on Human Relations. That's a separate bill that deals with 55 and older communities and Civil Rights Act violations. Senate Bill 476 deals with law enforcement vehicles. Associations can't prohibit a law enforcement officer from parking his or her assigned law enforcement vehicle in certain areas. Senate Bill 140 dealt with HOAs and whether they can adopt rules restricting use of fireworks on designated holidays. So I'm just kind of flying through those. Those are some other bills that do affect associations, but in smaller ways. But the big bill is Senate Bill 1084, which deals with emotional support animals. And so it brings a lot of clarity regarding this emotional support animals and how they're handled under the Florida Fair Housing Act. Before I speak to that, there was also a big case that came down recently that I just wanted to touch upon, which was Bailey versus Shelbourne Ocean Beach Hotel Condominium Association. This was a recent case. It's not necessarily final yet, but it's just something that should be on people's radar. It deals with material alterations. This case dealt with an issue of whether a vote after material alterations had been started and done could ratify the material alterations after the fact. This is something that happens, right, in the past. There's material alterations that are done. There's a question of, you know, there was no member vote. Can we ratify it after the fact? Now, a couple of years ago, the law was amended to say that where you need a membership vote of 75% under the statute, you need to get you cannot ratify a material alteration after the fact. You must get the vote before you start. But it was unclear whether that applied to declaration alterations, like alterations whose approval is governed by the declaration as opposed to the statutory 75% requirement. So what happens with material alterations is they are approved either pursuant to the declaration, if the declaration has a provision, or it takes 75% of the members to approve a material alteration. But the case explains how material alterations don't include necessary maintenance, right? Repairs, etc. And this appellate decision explains the difference between necessary maintenance and material alterations. And then it talks about, well, some of the work was a material alteration, and the case decides that you can never ratify a material alteration after the fact. you know, by nature, by the way that material alterations are and the statute's written, we interpret the statute to require the vote to be before the alterations are done. So that's a significant, you know, because that's broader than just when the 75% requirement applies. And the statute wording suggested it would be only when the 75% vote applied, but the case was broader. So it's subject to further review, potential, you know, rehearing motion, maybe review to the Supreme Court of Florida. But for now, that appellate decision does kind of change things regarding alterations a little bit. So it's good to be aware of it. So to get back to the emotional support animal changes, first of all, there's the Federal Fair Housing Act and the Florida Fair Housing Act. And so what happened was the Federal Fair Housing Act has been interpreted over the years to deal with emotional support animals and to prevent associations and other housing providers from, you know, denying a reasonable accommodation for someone with a disability, and that when the accommodation is they need an emotional support animal and they need exceptions from typical pet policies for their emotional support animal. But in Florida, there's a separate Fair Housing Act law called the Florida Fair Housing Act. And the Florida Fair Housing Act is a little different from the federal, but they pretty much overlap. And the Florida Fair Housing Act was kind of silent on emotional support animals. It didn't really go into it, didn't provide clarity. But what also was happening was there was this cottage industry that everybody, you know, can think about of like getting emotional support animal registrations from the internet, you know, and having these cards that say, oh, the animal is registered. And associations' hands were tied because there's very little you can do under the Fair Housing Act to verify disability and emotional support animal claims beyond what's permitted by the regulations and the statutes. So like you can ask for certain information if the disability is not readily apparent or if the need for the animal is not readily apparent, but you're limited in what you can request, and it's very technical. And in Florida, there was really no guidance and clarification on this issue until now. So the new law, first, it provides clarity and supplements the Florida Fair Housing Act to deal directly with emotional support animals. And so it now codifies that emotional support animals are protected. It explains the protections for emotional support animals, defines emotional support animals. You know, now emotional support animals are unequivocally protected under the Florida Fair Housing Act. But as a trade-off, the law cracks down on these use of out-of-state providers and online certificates. And these changes are pretty significant. So first of all, out-of-state providers have to have personal knowledge of the condition, and there needs to be at least one in-person visit for the out-of-state provider to provide a basis to document the need for the emotional support animal or the disability. And that's a very
but what about during COVID? What about during COVID and you can't get to your in-person meeting with your medical provider?
Yeah, it's a great point, you know, but it's out of state only. The medical providers in state don't have that restriction. So you see what they're doing. They're trying to crack down on that Arizona physician who's like registered online and like, you know, soliciting, you know, to send cards, you know, and I'm not going to demean this process. You know, emotional support animals are necessary, reasonable accommodations for people with disabilities. You know, they help people with disabilities cope, and they're essential. So I'm not here to snicker at that. But there is controversy over this process of requesting certificates online. There's a question of whether it's really bona fide, in good faith, and accurate. And so there was a lot of controversy about that. So now there's criteria in terms of who you can rely on to document your emotional support animal and disability. I will say the law still prevents associations from requesting specific diagnoses or the extent of the condition. The association cannot dig into like the medical information of the person. The association can have a streamlined process, which, you know, it generally is a good idea to document a streamlined process so you can show compliance with the requirements of the Fair Housing Act, both federal and Florida, you know, through documenting reasonable inquiries, you know, the acknowledgement by the person that you've, you know, handled it in good faith and reasonably. You can put in place like a streamlined, you know, questionnaire or whatever it is that you have, forms and you know, I wouldn't say application, but like forms and documentation relating to the requests that you get. But the law says, while you can do that, you can't require the person who is you know, bringing in the emotional support animal and requesting the accommodation. You can't require them to jump through the association's process hoops to have that accommodation. So if the person says, nah, I don't want to fill out your form, I'm entitled to it regardless. The association has to back down and can't be like, we're not going to allow that animal unless you fill out our form. Now, of course, if it's not really an emotional support animal and there isn't a disability, then there's no rights. But if it is an emotional support animal and there is a disability and there's a litigation, you know, the association is going to have a problem if they didn't allow the accommodation solely because they didn't, the person wouldn't fill out the paperwork that the association wanted them to fill out. I will say that there's now criminal penalties for the person seeking the accommodation, right? So if somebody's seeking an accommodation, falsifies their information, provides false documentation, they commit a second-degree misdemeanor. Within 6 months of conviction, they have to perform 30 hours of community service for an organization that serves individuals with disabilities. There's also codified into the law, you know, an exemption for an animal that is dangerous to the community. So the association doesn't have to give an accommodation for a dangerous animal. And you know, the associations have dealt with the Federal Fair Housing Act relating to these issues, so there's a lot of overlap here. You know, you still can't charge like a fee for an emotional support animal. You can't, you know, you can't deny access to certain areas just because it's an emotional support animal. And of course, you can't enforce pet restrictions against an emotional support animal if the documentation has been required. So those are all big changes.
So guys,
I know emotional.
We only have 5 minutes left, so we're going to have to move on. So let's, because I also want to take some questions from the audience. So shall we do a couple of the following updates and then move on to questions and answers?
Yeah, they're very quick.
Sure.
The 55 and older community update deals with housing for older persons. So under the Fair Housing Act, you know, there's discrimination that's not allowed on the basis of familial status and age. So what happens is it's generally discriminatory to say, well, kids can't be in a community. However, exemptions to the Fair Housing Act, Florida and federal, exist for housing for older persons under certain requirements. And so what happens is in Florida, there's a Florida Commission on Human Relations that administers this. And previously, associations that wanted to have housing for older persons, 55 and older, had to have what's called they had to comply with what's called the 80-20 rule, where it's like 80% have to be over a certain age, et cetera. And there's documentation of that has to be maintained. And what happens is every couple of years, they had to send a letter to the Florida Commission on Human Relations. And whoops, you know, what if they didn't do that? Because it's like an onerous, ongoing thing you have to do. But now the bill removes that. You no longer have to deal with that. The Florida Commission on Human Relations no longer collects those letters. So that's been taken out and it's a requirement that's been removed. That's really the extent of the change. There's also some changes regarding the Civil Rights Act, but I won't get into that here. Then the other change I just wanted to briefly touch upon is committees. The Florida Not-for-Profit Corporation Act had changes this year, and the Corporation Act, that deal with committees and how they can be constituted. Condominium associations use committees for all kinds of purposes. The only types of condominium committees that the statute says it doesn't apply to are disciplinary committees. So like fining committees. Any other committee arguably must comply with not only the Condominium Act, but also the Not-for-Profit Act. Because the way the law is written, it says if the Condominium Act is silent and doesn't counter something in the Not-for-Profit Act, the Not-for-Profit Corporation statute may apply. And so it applies. And so the Not-for-Profit Corporation Act has now new requirements for committees. You know, if the committee is going to have board powers, it must have a majority of directors, et cetera, et cetera. There's all sorts. So if you're doing committees, it's important to talk with legal counsel about, do these changes apply? Are we doing committees correctly under the new Not-for-Profit Act requirements? So that's,
Nice. You said all of that in about 2 minutes. I'm very proud of you. So we're in the question and answer portion of the webinar. So David, I think you wanted to chime in on something. I think this is a great opportunity to do so. I'm sorry that I interrupted. I just we're running a tight ship today. So.
Oh no, I was literally about to. I was going to say the same thing, that we were coming up on an hour.
I was going to
cut Jonathan off
for another hour.
So, okay, so I have a few questions here. We have a bunch, guys. I'm really, really sorry. I'm not going to be able to answer all of them, but if we don't get to it, again, you can email info@castlegroup.com and we will get back to you. Okay, so Barry, can a DocuSign be used for unit owners to vote on a limited proxy even though there is no identity authentication, and section 718.128? This is from Barry in Dade County.
Whew. Very specific question. David, you want to take it?
I feel like Barry's an attorney. He keeps asking a lot of legal questions. So I'm like, is Barry an attorney?
He probably, you know, I can think of some Barrys I know. So first of all, with a limited proxy, I think you could use DocuSign. There's ways. I'll leave it at that. You know, you'd have to look at different things, but I think generally, yes, it's not something that I would not be so restrictive to say it has to be physically signed.
I would point this out. Half the time you're not getting what we say in real estate or condo law, a wet signature. You're not getting this original signed proxy with the blue ink and a corporate seal or a copy of the driver's license. Someone is signing it. They're signing their proxy. Half of the people now are taking pictures with scanning apps on their mobile phones and then emailing it in. Because remember, you know, on proxy voting items, it's not the secret ballot, it's not the inner ballot. It's people are just signing these things and often emailing or faxing them into the management office.
Right. And also the Not-for-Profit Act a couple years ago, the Not-for-Profit Act changed some of the proxy requirements generally for corporations and dealt with new rights to use electronics relating to proxies. So I would also look at that, and I think it supports, you know, being able to use DocuSign and deal with you can email in proxies now.
Right, because really, in terms of the identification issue that was raised, there's no identification verification if someone signs a proxy and then scans it and emails it in.
Right.
Okay. All right. So I have another one. Audrey, I think this one's more for you. It has to do with operations. So preparing for hurricanes during COVID-19. We got a nice little scare with this storm that was coming our way and luckily missed us. So what are you seeing happening out on the ground and in the field with that?
Well, it's funny because we had a webinar on this, I believe, last month, right, in preparation. So, you know, we prepare well in advance of hurricane season, and we did make some, you know, some minor adjustments to our plan to really accommodate social distancing, right? And I think the larger part of the plan, because the team works together to kind of button up the community, but the larger plan as well is just being considerate of our board members or our residents in the community who are stuck here because of COVID and weren't able to go back home, right? And educating them and making sure they know what to do well in advance of a storm and make sure they're prepared and have everything they needed in place. So, you know, I expect all of our communities to have a hurricane plan in place. We reviewed them, we went through our drive runs, we made the COVID adjustments. And we fared well, and even with this storm, whether it was going to be tropical or not, you know, all our properties went through the exercise and we got our communities ready and we were ready. So
good to hear. Okay, and then I have one here. This one kind of makes me laugh a little bit, but what do you do with the resident who claims he is medically exempt from wearing a face mask but refuses to submit paperwork?
Oh, so first of all,
it depends.
Yeah.
You're here to expand.
If someone is wearing a respirator or breathing assistance and they say they can't wear a mask, I'm going to tell them they're exempt. That's my easy answer to it.
Okay, simple enough. I like that. Okay, guys, so we're a little bit over time, but it was really a great discussion. So I want to personally thank Haber Law, David and Jonathan. You guys did a fantastic job. Great conversations. And if you want to reach out to them, this is their information. You can call them directly on their cell phone. Tell them that you saw them at the Castle webinar, and they'll treat you extra special. And it's a great opportunity to get free legal advice. So do it now, because it's not going to be free forever. Yeah, feel free to email and such. I'm sorry, Audrey, what was that?
Offset your rising legal costs right now.
There you go. Do you guys have some parting words before we end?
Well, first, I would like to thank everybody, who attended, Audrey, Jessica, Castle Group, David, and, everybody who participated in this, and would like to wish everybody well and to stay safe. David?
Thank you very much to Castle for putting this on, and thank you to everyone at Haber Law as well that helped. A lot of work goes into these presentation and Zoom meetings, and we really appreciate it. And just like Jessica said, please reach out if you have questions. You can call, you can email, and I can't promise it'll be 100% free. I do need to make a living, but happy to help and have initial consultation. And I see some of the people are probably directors or managers at properties that we work with. So we'd like to hear from everyone and hope everyone stays safe with, we have the pandemic, we're in the middle of hurricane season, and many other things that are going on as well. So thank you very much, Castle. We really appreciate it.
Great.
Thank you.
That's David's table, right? I'm always offering things for free, and David's like, hey, stay on the next day. So guys, thank you so much. A little bit about Castle Group. Obviously, we're your premier choice for property management. We have partnered with over 360 associations statewide and in Texas. If you have any questions at all, please reach out to us at info@castlegroup.com. Follow us on LinkedIn, follow us on Instagram and Facebook, because that's where we post all of our webinars, all of the things that we have going on. Throughout the month, we have so many resources that are for free, legitimately for free, that we'll be more than happy to share with everyone. Audrey, do you want to say a nice goodbye for everyone before we jump off?
Yeah, I echo Jonathan and David's sentiments. This is phenomenal. I love to connect with residents in our community, in our local areas, and just kind of answer a lot of questions that you're faced with unprecedented times. So this is great to connect this way and hear everyone's input. So thank you all. Continue to be safe. Castle is here. If you have any other questions, like Jessica said, just reach out and we will be super thrilled to help out.
Excellent, guys. All right, well, everyone have a wonderful afternoon, and we will see you in the next webinar. Bye-bye.
Thank you.
Bye. Thanks again.
Bye.